organized for the university by the collaboration of the Central Office of Research, the Postgraduate College, and the Postgraduate Student Association of Obafemi Awolowo University, Ife. Today is another edition, and in the series, we have we've had quite a number now, and in this period, we are focusing mostly on literature reviews, and most of the things we've done in the past 3 to 4 weeks have been around this topic. We want to continue in that light by looking into something that is also an important part of research, but then has an impact on literature reviews, but then more importantly, also has an impact on research as a whole, and that is on intellectual property rights in the academia. We want to look into what every researcher should know. And I see people are joining, but then we are on the hour. And so I want to welcome the Director, University Research Office, the person of Professor Babajide Odu, and the Deputy Vice Chancellor, Research, Innovation and Development, Professor Akoni Akinyemi. We also have here Professor Adereti and other eminent professors. I want to say you're welcome, sirs. To start us out, as is the custom, I want to invite Professor Akoni Akinyemi to welcome us while as more people come into the room. Thank you, sir. Professor.
Thank you, Dubigi. Yes. Good morning, all. Please let me invite Professor Jide Odu to please welcome us and also make a remark and also invite the speaker. Thank you. Professor Odu, Director, please.
Thank you, sir. Morning to every one of us. Thank you for coming to this, for attending this presentation once again. I want to recognize my Deputy Vice Chancellor, Innovation Research, Innovation and Development, Professor Akoni Akinyemi. Thank you for inviting me to welcome everybody. So, in that light, I welcome everybody to this presentation, especially I want to thank Dr. Caleb Badilowo for agreeing to present this particular topic. It's an ongoing discussion because it's very important in our world today and the academic world. Every researcher should know a lot of things, everything that has to do with intellectual property rights. If you want to be relevant in academics, you need to know everything that has to do with intellectual property rights. I want to say that we should listen. This is an ongoing discussion. It's something that we have been, having position on from a long time. We had this just recently this week. We had the World IP Day, and then we had a discussion around so many issues in sports, especially, and then this is an ongoing discussion. So we would love to hear what Dr. Caleb Badilowo is going to give to us this morning, and let's listen and then let's enjoy the topic. Thank you. So over to you, Dimeji. So maybe you can introduce Dr. Caleb Badilowo to us, and then let's listen to him. Thank you.
All right, sir. Thank you very much, sir. I want to invite Dr. Caleb Badilowo. Is the Deputy Director of Research at the National Center for Technology Management, the office in Obafemi Awolowo University, Ife, Nigeria. He's an expert when it comes to IP and how it connects to different fields. And today he will be introducing us to what we should know when it comes to IP. And at some point, he would also be telling us how this connects to the literature review that we do. By next week, he will also be taking us on sourcing for different sources, sourcing for materials for your literature review and your research in different platforms. But then for today, we are looking into IP, and it is our honor and joy to invite Dr. Caleb Adeloro. You have the floor, sir.
Thank you very much. Very beautiful morning to everyone. And you see, it's a great pleasure to be with you today. I really appreciate all the good works that you have been doing all this while. At least I've joined quite a number of webinars on this platform. So thank you very much, especially the DVC for the great work you are doing. Thanks so much. And of course, the PG Provost, thank you so much. I'll switch off the video for the sake of bandwidth. Am I audible, Mr. Dimeji?
Yes, sir. Yes.
Very well. Thanks so much. Just like I've been introduced, Caleb Adeloro from the National Center for Technology Management. I joined scholars in the field of intellectual property since 2010, and I've been consistent even with that. When I got the master's degree in intellectual property from Africa University in Zimbabwe. And of course, that was after I completed my first degree in Obafemi Awolowo University. And on return from the master's, I did master's again in technology management in Obafemi Awolowo University. And of course, I did my PhD in technology management. And of course, I work at the National Center for Technology Management. So I've been a very passionate follower of IP things. So to get us started this morning, I want to acknowledge first, I would like to acknowledge the DVC for this great opportunity that has been extended even to me. And of course, the provost and then the member of staff at the DVC Research, Innovation and Development. And of course, my friend, Mr. Adewale. Thank you so much for this great privilege. So by way of introduction, it is very important that following the discourse over the last few weeks has been on literature review. But then one of the critical literature sources that is often neglected by researchers is patent documents. And this is a vital part of what should constitute literature review for researchers, especially those who are looking towards coming up or developing new technology within the university, which of course is critical even to national development. It's not just to research, but research for what? It has to be on purpose, and that purpose for it to be realized, you may need to start from where others have actually stopped. So the focus today will essentially be on intellectual property broadly, and of course, what should be the strategy for researchers going forward in terms of our attitude, researchers' attitude, even towards intellectual property per se. So within the next few minutes, we're going to be discussing intellectual property. We'll zero in on that. So questions may come, you can put them in the chats, and of course, we're going to open the floor for discussion later. So by way of intellectual property is a subject that is becoming so popular, especially today, because the world is ruled by innovation. And without the intellectual property gateways, innovation may actually be very difficult to manage, essentially, especially when it comes to ownership of innovation and then who does what, who owns what when it comes to innovation within our system. So frankly, what exactly is intellectual property? Is in its very simple definition, is the creations of the mind. Whatever the mind can actually think of or come up with is what is defined as intellectual property. And we have the example of inventions, artistic works, designs, logos, names, and many other types that we can name. And of course, shifting to intellectual property rights. This is transitioning beyond having IP, that's the creation of the mind, to having it in a legal form, meaning now you have a legal document to support your intellectual creations. So is that legal right that is being given to you for the purpose of what maybe inventions that you have created, or the book that you have published, or whatever you have come up with from your laboratory. It could be a recipe, food recipe, and the likes. And of course, all of these are very critical because most researchers work in this domain. And essentially, this is the broader categories of intellectual property. When you divide it, the categories are actually two. You have the copyright and of course, industrial property. Under the industrial property, that is where you have all other types like trademark, patent, industrial design, geographical indication, trade secrets, and plant varieties, and all sorts. But essentially, when it comes to copyright, is one of the prevailing IP that is generated within the university or in the university community, because essentially the interest is once you have a new result from your laboratory, the next thing is for you to begin to discuss it, even with colleagues at conferences, or begin to publish in a notable journals. So that is where it begins. For copyright, the protection is automatic. And also it is important to note that copyright doesn't protect ideas. It should be noted. Until you put that idea into a material form, that is when it becomes protectable. So it protects original, literally artistic music, dramatic work, film, sound recordings. And this is where copyright also has a kind of add-on rights, which is called related rights. So it is one thing for you to write a novel, and then other people can pick up a novel and begin to act that novel. You know, the novel is copyrighted, and then another right is emerging when you begin to act even that novel and put them into images, and then you turn them to films. So all those films, they are what is called related rights, essentially, which of course, it gives the creator exclusive rights to reproduce, distribute, perform, or adapt the work into whatever forms that they want. And next to that is the trademark, which is under the industrial property, which of course protects logos, symbols, names, And we see the examples like Nike, McDonald's, Apple, and the likes. And of course, within our context in Nigeria, we have Flutterwaves, we have GT Bank, Logo, and all of that. All of those are protected by copyright. And when you look at the sign beside that copyright, that TM, so meaning trademark can either be registered or the unregistered one. The unregistered one is the one you have with TM, but the registered one, to put it in R in that same circle. And of course, when it comes to patent, this is what is mostly preached in the universities, because we believe so much with all they do in the Faculty of Science, Faculty of Technology, Agric, Pharmacy, even medicine, and the like. So this is where tools are required for their operations, essentially. So most of the activities they engage in terms of research are purely targeted towards developing new solutions to existing problems, or new solution to new problems or emerging problems in their respective fields. So it protects inventions or innovation that are novel, which involve an inventive step, capable of industrial application. It also gives the inventors the exclusive rights to make, use, sell, import, and the invention for a limited period of time. You know, the limited period of time is 20 years, essentially across board globally, 20 years for patents, so that you have all the opportunities to really harvest the benefits of this patent, to recoup your investments in the production of that so that is the kind of to researchers. And of course, the arts. You see, previously we've seen different ways by which the design of tables, wristwatch, bottles, and of course cars, mobile phones, the way they have evolved even over time. So all of this design, they are qualified even to be protected by intellectual property, which of course is industrial design. And of course, the geographical indication that talks about the quality of the product coming from a specific region, which the quality is essentially due to the climatic condition of the place, and then existing technological capability of the people in that environment. So more details, we can talk about more detail maybe in a later lecture. But for today, let's just get the definition and see what is there. And then some of the examples that are put here. And the trade secret is also an important part of intellectual property. We're going to see some examples. These are just typical examples in terms of pictures. We're going to see more details later. So, but we should also note as researchers that when we talk about invention, it's not the same as innovation. Invention, this is the intellectual creation. If you remember what we looked at earlier or previously, IPR, you see, intellectual property is different from intellectual property rights. IP generally, they are the creation of the minds, things that we can create from our imagination, out of our imaginations. So these are basic inventions. As long as you have them in your laboratory, as long as you have them not yet being introduced into the market, is still an invention. And the best intellectual property protection for invention is actually patent, as we mentioned earlier. So patent in itself does not constitute innovation until this patent is worked and then products are produced from it and sold on the market or used by the community, it is not innovation yet. So when it moves to the innovation part, that is when it is available. The product of that patent is now available even to people in the community. People can then begin to use even the products in the market. And of course, we should also understand that there are a lot of intangibles that business may own, universities may equally own, especially in our laboratory. There are a lot of, the skills that we have. There are things that are difficult even to quantify, essentially. But in terms of intellectual property, is also a form of intangibles, but which, of course, extra effort have been spent on them to make them look somehow physical. It's just like you have tangible assets like land, like machinery, like all of those plants, they are tangible assets. But the intangible ones, they are those ones that we cannot see. But when it comes to intellectual property, we can see it, we can feel it, we can even touch the documents, especially when they are protected using the conventional legal framework. So you can see the documents that give you the authority to own even that IPR. And of course, I did clarify earlier the issues between intellectual property and, of course, intellectual property rights. They are not the same. They may look the same, but they are not the same. Until you have the right, all you have is just the intellectual creation. You can turn it and make it IPR when you have the legal backing and then the legal ownership in front of it. And of course, even in the advanced country, and especially even the emerging economy, they are now using patent documents as collateral, even for businesses, especially Singapore has started that, and then Switzerland is also looking at that at the moment. There are a lot of programs that have been held to see how IP owners can begin to use their IP assets as collateral for business. And of course, confidential information is also different from trade secrets. Trade secret efforts must be made to keep those confidential information secret before you can play ownership even up to it. And there are different perspectives and then advantages to trade secrets and of course to the conventional IP system. So in the space of intellectual property as well, you have some that are registrable that you must register them to own them. Whereas you have some that you don't necessarily need even to register them. But like I mentioned earlier, there are pros and cons even to all of this. For instance, if you have your patent in terms of your IPR, meaning what you need to do is to disclose to the government what exactly your patent covers, meaning your claims, things that you have invented from your laboratory. So as soon as you make that public through patent, the government will help you to protect it for 20 years. So beyond which it lapses, and then anybody else can pick it and use it, right? But when you go the route of trade secret, it will be difficult for anyone even to practice it, but you must make substantial effort to ensure that yes, you keep those secrets secret, because the moment you are careless about it, anybody can just pick and then do the reverse engineering, and that will be end of that intellectual property called trade secret. And of course, copyright, you don't even necessarily need to register it, right? To own it. The moment you create it, the copyright subsists automatically. But the burden of proof make it important for you now to probably deposit a copy with or register it with the Copyright Commission and the likes. Yeah. So all these rights, plant breeders' right, designed as industrial design, integrated circuit, and then of course trademark and all other that I mentioned earlier, they are subject to registration. It's through the registration that you can actually have all of those ones. And when you see a cup of tea, there are hundreds of intellectual properties that goes into it. And this is exactly what we are talking about. Even the mobile phone that you have in your hand, thousands of intellectual properties are embedded even in a singular product. So this is what gives IP a very veritable ground in our society as a kind of precursor to innovation, driving new products and processes in our society. And of course, we also have the bottle of Coca-Cola that we all take. We know there are a lot of intellectual properties that are associated even with Coca-Cola as well. The bottle cap is protected even by the by technology of patents. And of course, you can also look at the process of producing the machines that are involved in the process are also protected by patent. And then, of course, you have the industrial design, the shape of the Coke. There is no other beverage company that can use this shape even for their products, because this has been registered even for Coca-Cola. And they have quite a number of them, which of course no other beverage industry can imitate. And of course, the content is protected using a trade secret. You can imagine since when Coca-Cola has been established till today, they are still enjoying that trade secret. So as long as they can keep it secret, they will continue to enjoy even that, that benefit. So nobody has ever come across how they do even the formulation, and then they have been able to keep it secret for hundreds of years. And the same goes for the McDonald's as well. That is what they are also benefiting greatly from. The same applied to KFC, that's Kentucky Fried Chicken, is that secret that they have. And of course, the packaging, they are copyrighted. And of course, you know the name. When you mention Coca-Cola, even the way that Coca-Cola is written has been customized. So no other company can write even that way. Everything is protected. And this is how you secure your holistic business engagement, and why intellectual property is very critical to business success, and of course, even to the university system. The name Obafemi Awolowo University is unique globally. So any product that has that name, any design that has that name, before you even think twice, it's Obafemi Awolowo University they are referring to. So it confers that advantage upon any business. But globally, what is the pattern of intellectual property application? Is just for us to see some of what is happening globally. I attended a course last year, and all of these beautiful analyses were done there through WIPO websites, total worldwide application. You see the number of patents that are in force, and then the utility model, the trademarks, the industrial design, even the GI, all of those ones, they are equally there. And you see almost every year, all of these filings are being made globally. And these are IPR that are in force as far back as 2023. And of course, which country is number one? Can anybody guess? country with the highest number of patents globally, even since 2020, 2015 to date. Yeah. Can anybody guess? Yes?
China.
Germany.
China.
Germany.
Oh, yeah.
That's the China.
Fantastic. I
China.
like that. You are very correct. Yeah. It's China. They are there. They are the one now leading. You know, a very clear analogy of this was I started work with NASETEM in 2009. By 2010, early 2010, my DG then, Professor Shiambola, gave me an assignment to look at, because that was when I returned from the master's degree in intellectual property from Zimbabwe. So he asked me to look at the patent pattern and the growth of patent over time. So when I delved into that database, of course, you know, WIPO has the big portfolio of patents globally. And then all the IP offices, you can look at EPO, that's European Patent Office. China also have their own patent office. So what I'm saying is you just see by margin of few numbers, China is trying to exceed the US. So, but today the gap is clearly wide. But you know, China, yes, they have the number. And of course, what about the quality of patent? You know, quality of patent also matters. That is, to what degree can your patent stand the legal battle? You know, because most of the challenge, I mean, maybe I shouldn't go there so that I don't derail. So the quality also is also called to question here. And of course, this is the trend. And when you look at this is the trend in terms of how they move over time. When you look at that around 2010, look at China, which is the blue one that is now up, and then the US that is second. Look at the time when they actually met. It's around that 2010. And then look at the wide gap between then and now. And you can imagine how much they have really pumped into research and development. And when you look at small country like Republic of Korea too, you know, they are also making a big wave in this line. And it's not surprising that those countries that you saw making waves in terms of patent application are also the ones that are leading on the Global Innovation Index, even beyond the fact that, yes, we don't really have much data within our domain, within our system, even to support the computation of a Global Innovation Index. But the fact remains that those countries that have always been spending so much on R&D and, you know, having so much patent are equally those ones that are leading when it comes to Global Innovation Index. And this is a Brand Finance Global 500 that was put together in 2024. You know, you will here they consider the amount that each brand actually commands in the market. And when you look at all of them, you can spot China in 4, 5, 6 places. And of course, US has always been there, the US companies, I mean. And then you can see a number of German companies as well. So you can see the more you spend on R&D and the more coordinated your R&D system is, the better for the economy. So for us in Obafemi Awolowo University, we may need to think and reflect on what exactly do we want to benefit from as the output of our research. I know we are doing research to get promotion, we are doing research, you know, to move ahead in our career. At the same time, we must equally think of what can come even from the results of our R&D, so that we do the R&D that can have impact even on the society. And these are general benefits of intellectual property, especially coming from what we have seen, even from the picture. Intellectual property are happy to take technology achievement and of course, other intellectual assets. Then it makes technology information available to the public. This one, we cannot emphasize it. We can't say it enough. Most researchers in developing countries are not using patent document for research, which is making work like begin again. You're starting again. You want to develop certain technology that can be used in the, maybe especially in the agri setting, to help the farmers, to help them improve and then reduce post-harvest losses. All those technologies are available. And in fact, very many of them are already in public domain, which of course we can leverage. So instead of starting again, these documents, they are there even for researchers, even to use. And if you don't know how to access them, thank God there is Intellectual Property Technology Transfer Office in Obafemi Awolowo University, which of course everyone can leverage. And of course, even if you don't want to go to their office, they now have OAU Innovation Digital Platform, which are freely available that you can access online and see how you can actually contact them and then get relevant assistance even from them. So, and of course, intellectual property is a critical mechanism for harnessing value from R&D efforts. So, like I mentioned earlier, you don't just do research for doing sake. Today, most nations and most countries, they place high value premium on R&D efforts because that is what they survive on. And they will want to see, before any industrialist can commit fund, they want to see what is going to be the outcome. And essentially, when we are designing our research, we can look at the national development agenda or the global or regional development agenda and ink our research even on that. So it's going to attract relevance. We have the Sustainable Development Goal, Renewable Agenda is there, CISA 2034 is there. So all of those are there that are telling us that yes, R&D shouldn't be done in isolation, but should connect even to the needs of the society, especially the industry. And of course, intellectual property equally enhances the transfer of technology, especially for employment, growth, contribution to national GDP, promotes and strengthen. You know, all of this, when you look at all of these companies, where they are, you can imagine how much they are making for the economy, and of course, the number of people that are working in that company. And of course, intellectual property also prevents the need to reinvent the way to do what has already been done. You don't need to waste resources on research that we already have the results in the open, in the public domain. And it also signals good science with great impact. This is also very key. If your research is targeting needs in the society, this is where it's going to be it's going to be noticed. And of course, when you look at webometric ranking also, because this impacts the good science equally impacts on the ranking of the university. So that this is what this statement is actually referring to. When you look at the recent ranking, you see excellent research as part of the index or indicator of webometric ranking of university, which we're going to see some of the typical ranking and then how it impacts on how good science in the system can actually have direct consequence on it. And then for IP to become naira, dollar, pounds, it has to connect with the industry. But this is not where we are going today. We're just making us to see what should be our attitude towards intellectual property. And this is what I was saying. This is 2025 ranking webometrics. The new one is out, and I think I have it. So what actually changes, UI moved to 22, and Unilag moved to around maybe 25 or 23. So they just follow the same way. But essentially, when you look at the number of our universities in Nigeria, you see the number, 280, then 281, just growing. And then all African university on that, 2,095. And when you look at the number of polytechnic, teaching hospital, and research institute, we have the number, right? But when you look at the ranking, most of our universities are not on the rank here, meaning something is wrong somewhere. Maybe we need to pay attention to excellent science much more. And of course, I know there are barriers, but we're not going to be talking about the barrier. We know they are very important as well. Yeah, but we can do better even with whatever resources that are made available, even to us as well. But one interesting thing that I will also point out here is when you look at most of the universities that are doing very well, even in South Africa, go there, you see a lot of Nigerians. They are also there. So, and of course, for the requirement for patents, it has to be new, meaning universally new. It has to be new to the environment and to the global community. It has to have inventive steps. These inventive steps, probably because we don't do what is called substantive examination in Nigeria, so we don't dwell so much on these inventive steps. But the meaning is very simple, meaning somebody who is an expert in that field shouldn't just wake up and be able to come up even with the solution you are claiming is your own. So it shouldn't be a very straightforward affair, meaning we already have chair tables. We've been using that for long. And then you are coming up with 5-leg table. So what is new there? You just put additional leg even to it. No, nobody will take that from you, except there is a minimum requirement in terms of usefulness, which will make it new. That is, without that addition, maybe the existing technology wouldn't be able to give us the optimum benefits. So it has to have that inventive step. And of course, industrial application and many other specific national issues can equally come in. And of course, for patent application, please, I will not dwell so much on this. I will say, visit Intellectual Property and Technology Transfer Office in the university, or visit OAU Innovation Digital Platform. Everything is going to be explained to you there. It's because of time, because you can see that the time is just flying. And of course, this is going to be my last slide because I want to dwell a bit on it. The strategies. Now, when we started, this is where we are going to wrap it up. Strategies for managing intellectual property by researchers. And I want to, make it very quick as well. In terms of awareness, please educate yourself. Even when you are signing research agreement, research collaboration with other institutions, other researchers from across the world, make sure you establish the content of that agreement to see what is there as part of the intellectual property. Most of the donor institutions, they will want you to cede the intellectual property to them. And if you are not willing to do so, but because they are giving you money, you are so excited, you just sign the document without reading them. It's important so that you don't just sign out the most critical outcome of your research. So educate yourself and your team on intellectual property. And of course, use patent document for research. Use patent document for research. Like I said, we cannot overemphasize that. It is very important. It's very important. And then, of course, keep record of your research. Have your lab notes, have your digital notes. Every correspondence should be tracked because it may come to a point that, yes, you will have dispute, especially when you begin to make money from the outcome of your research. At the beginning, when things are rough, nobody may look at your side. But when you begin to make it, they begin to beam a searchlight and say, where is this? Is this not the same work that we have done together? Keep records. It's going to save you a lot of hassles on that. And of course, consult IP experts, especially your IP office or IP desk that you may have in your faculty or in your research system. This is not limited to researchers on campus, it includes the students as well. It's very important. Postgraduate student, you may see yourself as an inexperienced researcher, but as you grow within the system, you begin to see your relevance coming even to play. So it's important for you to be abreast of what is going on in the IP space, especially as far as your research is concerned. And of course, develop your own IP strategy. It is very important. It is part of your own PR, how to, to make, carry yourself among researchers is important. Assess IP potential first, file for intellectual property, craft, commercialization plan, and be wary of public disclosure first. Sometimes when you have very fantastic finding, you always want your colleagues to know about it. You always want people at the global level to know about it. Be wary of that. Make sure you guard it jealously, so that by the time you begin to discuss with people, there will be people that you have signed non-disclosure agreement with, such that will not end your IP life at that point. So if you have question on that, I think it's going to be very important because of time. Then understand your institutional policy. Obafemi Awolowo University, for instance, they have research policy, they have intellectual property policy. Look at what is there. In fact, it is recommended that as a postgraduate student, as you are stepping to the university, these are documents that you need to look at to see what is in there for you as a scientist, as a researcher within the university, so that you can be abreast of the information, be aware of intellectual property and how you can actually or adequately manage it. And of course, seek to collaborate with industry. Collaboration with industry is a fantastic opportunity even for all researchers. This is where the impact of your research can be seen or can be demonstrated real life, where you will see that, this is, you can imagine if Obafemi Awolowo University during the COVID-19, they were able to develop certain product. I know Professor Elitoba Blessed Mori came up with one, what do you call it now? It's a mixture, and it has a lot of herbal mixtures that are good even for a kind of health remedy. So these are things that the moment you begin to partner with industry, you begin to see the relevance of your research. Chinese of these days have a lot of herbal medicine in the market, but in Nigeria, we only have a few. So we can look at what we have within the university, and then how can we leverage that even to interact with the industry. So these are great opportunity, and these are kind of strategies that I put together quickly for us to leverage. So, and I want to also conclude that yes, it is important. What gives the research that produce intellectual property is never done in isolation. If your idea is good enough, it's not meant to be kept anywhere. Share with your colleagues the idea. The people that you can vouch for, that you trust, share your idea with them and let them help you shape even that idea until it becomes a very great and useful product for the society. And of course, just like a build on even to the literature that we mentioned earlier, and I've emphasized that even times without number, make sure you use or endeavor to use patent document for your research. And as you collaborate, use relevant patent document for your research And of course, interact with colleagues and then work together, be aware of the policies within the system. The sky is just the beginning. So I want to really thank you for your attention. Thank you so much.
Thank you very much, sir. This has been really, it's been a learning thing. And of course, some of these things I've heard before, but I've heard about new things now. So I want to say thank you for this very comprehensive introduction to intellectual property rights and how researchers should take full advantage of it. I will now invite questions or reactions. If you have any question, please use the raise hand icon or type it on the chats. I think there's a question now from Idowudi Aoli, which says, thanks, Dr. Adelo. My question may not sound IP directly, but when you mentioned awareness issues, I decided to raise this. I published a journal, a paper, I guess, with Taylor and Francis in 2023. Ignorantly, I agreed to pay the publication fee. After the publication, they requested I pay over 600 USD, and I responded I didn't have. The matter is taking a legal dimension. What do I do? Okay, I don't know if this is within the public of what.
Yeah, actually, it's very interesting to see this coming up. And this is what you see, especially when we don't really take time to read all the, what do you call it now, post-review or post-review assessment requirement, even for publication. Because at some point, when they will be asking you to pay the publication fee, they might have added some clause which will include you paying for the general open access, even for that article, right? Meaning, apart from you paying for the publication, then you may need to pay for others that will view even that article as well. And sometimes when you are submitting, they will ask you, or they will have asked you, is it going to be open access or closed access? So all of these are very important for us to check all those boxes and tick them as appropriate. And when you flag whichever one that is not really clear to you, ensure that you get to the clarification point before you sign. So this is what you see at the end of the day. And when this is getting to a legal dimension, I think within the university, we have the legal officer in charge of the university, and then you can actually ask for the advice and you'll be appropriately guided, Dr. Ido. I hope I'm able to address that, yeah.
All right, thank you. Thank you very much, sir.
Thank you, sir.
All right, I think at this point, I want to invite the DVC for his, okay, before I invite the DVC, let me invite Professor Grace Ogunwusi, who is the Director, Intellectual Property and Technology Transfer Office, for her reactions. And after that, I would invite Professor Babajide Udu, then Professor Kenneth. Prof. Ma.
Okay, thank you very much, the moderator. Good morning, everyone. Good morning, my DVC. I want to say a big thank you to Dr. Caleb Adelowo. He's a very fantastic, I should call him IP expert. He's been a very resourceful person, and today I'm sure we've all listened to him and we've learned in a very unique way. He's good at breaking things down and helping everybody to comprehend it. So we want to say a big thank you to you, Dr. Caleb Adelowo. Thank you for the good job you are doing, and thank you for the impact you are making, and for making NASATEM and OAU to have the opportunity to learn and glean from your experience and your expertise. So thank you so much. As you were giving the lecture, I just told myself that I'm going to ask that this should also be put on our IPTTO digital platform, because I know that it's going to benefit a lot of people, not just on the COR YouTube page. So this is very good, very comprehensive. And I would just want to suggest that we bring him back again to speak to another aspect of IP management. I know that there are a lot of things that he can still tell us and teach the community to improve our learning and build our capacity. Thank you so much. Thank you,
Thank you so much, ma'am.
COR, for bringing in.
Thank you very much, Ma. I want to say thank you. Let me invite Professor Gabaji D. I think there is a question. Let me just
Two,
quickly
actually.
read. In 2 years, in the
There are two
patent
questions
certification
there,
document,
actually.
yes,
So, yeah,
must we
what
describe
do you
step-by-step
disclose?
procedure? Yeah,
Yeah.
and then
No,
yeah.
this is not what is expected in the patent document. Is the essential disclosure is your claim. What exactly do you claim, or you want to claim ownership of in that body of work that you have conducted? So, and this comes as you craft what is called claim. That claim, it has to be very strong and then very punchy, meaning shouldn't be diluted with any other information from the public domain. It should distinguish your work from others. So that is what you are laying claim to. The step-by-step procedure of the invention, no, because as part of the invention you are going to have, you also have what is called trade secrets that are associated with it. You know, that one also is another part of bucket of money for you. So the invention is there. Anybody with technical knowledge can work it and make it work. But there are also the dimension in terms of the recipe per se. What measure, what percentage do you put together to make it? So all of those ones, they are still going to be recited with you. So, but you, most of the time, they usually ask patent attorney to actually help you craft that claim. But we have experts in IPTTO, they will definitely put you through, and then you are going to get your patent. And then there are some research that may take a new dimension as the research progresses. Yes. My question is, at what stage can a non-disclosure be signed with the research team? At least, I think from the beginning, you can sign non-disclosure agreement in terms of under no circumstance should you go to any conference and begin to discuss what we are doing in this laboratory, right? Because the temptation will always be high. When they ask you one question about what you are passionate about, you just go to town and you wouldn't know when you begin to disclose what you shouldn't be doing, which is going to harm even the invention at the end of the day. Because the more, even if you are the one and they can, trace that disclosure to you, it invalidates your invention automatically because already in the public domain. So we need to be wary of that. So before start of project at the middle, yeah. I think that's just it. So thank you very much. It's a very good question.
All right,
Yeah.
sir. Thank you, sir. We are on top of the hour already. Let me quickly invite Professor Babajide before inviting the TVC. Professor.
Yeah, thank you, Dimeji. Dr. Dilo, I'm very grateful for you giving us this observation at this moment. It's something that we really need. Just like what I said, that it's going to be an ongoing discussion. Maybe next time that we come, we have to discuss about how we can make our inventions, commercial, viable. something that can go to the market, commercialization of such inventions, so that and then we also need to know about how to, maybe we bring somebody else for industry linkage of our, because most of this IP, we have so many IP, but they're just sitting on the shelves. They are not being they're made use of. They're not useful to us now. And then over time, we lose, rights over them. So we need to know how do we, link up with the rights industry to make them, work for us. So I want to thank you most sincerely, for this presentation. And I want to thank everyone who has find time to attend this presentation this morning. Thank you. So over to you, Dimeji.
Thank you, sir.
All right, sir. Thank you, sir. Without wasting our time again, let me invite the DVC, Professor King, for his question remarks.
Thank you, Dimeji, because now we are 1 minute above time. So, but let me quickly, first, let me appreciate all the organizers, Dimeji and team, Professor Odu for putting this together. Thanks so much. And for all of the participant attendees, let me sincerely appreciate you. This is the third time we are trying to define the rhetorics of holiday to attend something that is very important. And for me, that's very impressive, that even we can join today, that is Workers' Day. So I want to sincerely appreciate all for joining. And to Professor Caleb Adelowo, it's always a pleasure listening to you. And thank you for your dedication. Thank you for your devotion. Thank you for seeking out knowledge, particularly where it is so cloudy, where people look for other non-knowledge-based items. Thank you for sharing, also for your depth of knowledge with us. And as others have said, we are looking forward to even hearing more and tapping more from your wealth of knowledge. Thank you so much.
All right. Okay, thank you very much, sir. Dr. Adelowo, any closing thoughts so that we can close?
Yeah, thank you very much. I want to sincerely appreciate the DVC and, of course, all the great professors of our university that are on the call, and of course the postgraduate students. Even if we have undergraduates, you are all appreciated. And thank you so much even for listening, because the question demonstrated that yes, attention is really paid even to it. Thank you so much. And I appreciate Mr. Dimeji and the team. Very wonderful. God bless you and have a beautiful day, holiday. Yeah.
Thank you very much, sir, and thank you everyone for coming. Every Friday, 8 a.m., please keep it a date as we normally do. Next week, we'll be looking into another important topic. We're looking into platforms, for sourcing research materials. And I think this is something that is also key, in our literature review chapter of this series. So I want to say thank you, everyone, for coming. Thank you, Dr. Adelowo. Thank you, all the professors that joined, and also to our guys at the Central Office of Research. We say see you, everyone.